All right, patents. Patent is a grant from the government that gives an inventor the right to exclude others from making, using, selling an invention for a period of 20 years from the date of filing the application for a patent. I think there's all sorts of conspiracy theories out there that there are patents out there for engines that will run for like thousands of miles on a gallon of gas, stuff like that. Whether or not that's true, I don't know. But these patents do protect inventors, okay? And they are on searchable databases. You can actually do this yourself and search online, but you probably want to hire a professional to do a real search for advanced work, okay? Now, what is patentable? Whoever invents or discovers any new and useful purposes, machine, manufacturer, or composition of matter, or any new and useful improvement thereof, may obtain a patent thereof, subject to conditions and requirements of this title. Right? So if someone could figure out how to make a lightsaber, they could patent that. Okay? Even though scientists will say there's no way to do it. But if someone could actually invent that, they could take that and make a patent on it, and no one else would be able to use it for a period of 20 years. You also have internet patents. Software patents are now available. Patents for business process on the internet are also eligible for patents, such as, if memory serves, the book talks about how Amazon does business. It's patented. Patent infringement. If the firm makes, uses, or sells another's patented design, product, or process without the owner's permission, the tort of patent infringement occurs. So it's a tort, a wrongdoing. So what are remedies if you breach or you use someone else's patent? You can sue for relief in federal court. You can seek an injunction telling the person to stop. You can also get damages for royalties and lost profits. That's huge, y'all. We also have copyrights. Anybody here ever copied stuff out of a dictionary and turned it in as their own work? Yeah, you can't do that. It's plagiarism. Okay? But copyright is intangible property granted by federal statute to the author or originator of a literary or artistic production of a specified type. Alright, so what is protected? Well, there's a whole list of stuff on page 349. But I'll give you an example of this. I actually, one quarter, gave some extra credit, and I told the class to write a paper on, I think, contracts or something. And one individual actually copied contracts out of Wikipedia and turned it in. Didn't even remove the hyperlinks. Okay? So, was that copyright infringement? Probably. Wikipedia is a whole bunch of other authors out there that post stuff about the various topics. Okay? Alright, so infringement is when the idea is copy and infringement of the copyright has occurred. Damages include actual damages, statutory damage, whatever is set by statute, criminal penalties, copyrights in digital information. This started back in the 1970s. Courts held that loading a file or program to the computer's random access memory, or the RAM, constitutes making a copy for purposes of copyright law. So if you load something into your RAM, which is what your computer uses to actually operate, that's copying for copyright infringement purposes. For the development of this, the No Electronic Theft Act, prior to 1997, criminal penalties could be imposed under copyright law only if unauthorized copies were exchanged for financial gain. Alright? This has been extended to persons who exchange unauthorized copies. You see where this is going. Digital Millennium Copyright Act of 98 gave continued protection to owners of copyrights in digital information. Enter MP3s. Alright? Obviously, whenever I was coming through college, Napster was the big thing. And this is P2P, peer-to-peer. And it's sharing digital information between laptops and desktops and whatnot, meaning that you go to these sites and anything on your computer can be uploaded to another computer, and you can download any songs you want from another computer. And this, is copyright infringement. More and more companies were using this after Napster. I think it was Kazaa, and then there were several others. But the Supreme Court made a decision on this, and one who distributes a device or software with the objective of promoting its use to infringe the copyright, namely these MP3s, as shown by clear expression of other affirmative steps taken to foster infringement, is liable for the resulting acts of infringement by third parties. So they were getting people for even using or creating the software. Okay? And in fact, today, you'll know, you can go online, you can order MP3s for like $1 a shot. So they've tried to correct this. Trade secrets. Customer lists, plans, research and development, pricing information, marketing methods, production techniques, and generally anything that makes an individual company unique that would have value to a competitor. So these are trade secrets. The formula for Coke. Okay. International protection of intellectual property. The U.S. has been a party to a number of international agreements relating to intellectual property rights. Because, folks, this is real stuff. Okay. It's not just stuff that's out there. This is stuff that has value. As such, it needs to be protected from any type of infringement.